Good afternoon, everyone, and welcome to what I believe will be a wonderful session this afternoon, which is on cross-border data transfer. We will talk with a great group of experts on the latest of what's going on with transfers across borders. I'd like to introduce my co-host, Justin Antonipillai of WireWheel. Justin?
Dan, first of all, great to see you. It's great to be back after a couple weeks. And Dan, we had one heck of a discussion around the new Chinese data privacy law just a few weeks ago. And I'm just delighted, and I know you are as well, Dan, to welcome such a deep group of experts on the area of cross-border data flows. So I'm going to quickly welcome our guests today, and then let's jump into the discussions. First of all, from Orrick, I'd like to welcome Shannon Yaborski. Shannon, welcome to the discussion today.
Thanks so much, Justin. Thanks for having me here today. So just a really quick background, I'm an English and Irish solicitor. I went to law school in London and have been advising on European data protection issues for the better part of 20 years. And I moved to the US about 7 years ago, so cover US privacy as well. So cross-border data transfer is right in my sort of sweet spot.
Oh, terrific. Well, Shannon, welcome to the discussion here today. We're, as I said, really delighted to have you. And why don't I do quick introductions for our other panelists. Ken Propp here from the Atlantic Counsel. Ken, you and I had the pleasure of working together years ago during the Obama administration when you were posted at the European Commission consulate in Brussels. And you obviously have had a lot of experience in the data protection and privacy area, Ken, in those years and after. Welcome to our discussion today.
Justin, thanks. It's great to see you again and to be part of this never-ending dialogue that we have on transatlantic data transfers.
Yeah, and there's a lot, in just the last few years, Ken, that have been part of core developments around the world in this area. Just delighted to have you here. Over to Peter Swire. Peter, professor and law partner and professional witness on all matters privacy around the world. How about that? Peter, do you mind giving us a quick introduction before we jump into our subject today?
Oh, thanks. Hi to Justin and Dan. Pleasure to see you both. Well, right now I'm a professor who teaches security and privacy at Georgia Tech in our new School of Cybersecurity and Privacy, which is actually looking for academics who'd like to come be in a multidisciplinary school on these topics. I wrote a book for Brookings back in 1998 on the European Union Data Protection Directive, and I've been in and out of government and practice and teaching ever since. If you take the CIPP US exam, I'm the lead author for the book. So I've covered a lot of privacy things.
Well, great. And Peter, obviously, you were also a witness in one of the main data protection cross-border cases. We'll bring that up. I'll tell you what, during the discussion today, and you can give us a little bit of background on what it was like to actually be part of the Schrems case, which has been such a core item around cross-border data flows. So, well, Dan, why don't I kick us off, and maybe after the first round, I'll hand it off to you. Shannon, do you mind if I start with you? Just in the last few days, I think in late November, the European Data Protection Board issued some guidance around different articles in GDPR, and it fundamentally tried to give some points and guidance on what is an international data transfer. Is it a jurisdictional issue? Is it a sort of legal jurisdictional or a physical jurisdictional issue? This is obviously a very important issue right now. Do you mind giving us a little bit of your perspective on this one?
Yeah, sure. So it's really interesting because there's never been a definition for international data transfer, and it's been the subject of discussion and commentary over many, many years as to what actually constitutes an international data transfer. So the EDPB has provided us with a sort of three-pronged test now to identify whether there is a data transfer. And the first prong is that there is a controller or processor that is subject to the GDPR. And so, an entity caught by Article 3.1 or any of the prongs under 3.2. And then the second limb, if you will, is that there's an exporter that makes data available to an importer, which is important because there was always sort of this question hanging over whether any direct collection of data from individuals located in Europe by, for example, a US-based entity constituted a data transfer. So that's really helpful color there. And then the third prong is that the importer is in a third country, regardless of whether the importer is subject to the GDPR. So it's against that sort of backdrop of having that formula that we can now look at cross-border data transfers, which is tremendously helpful.
Yeah, no doubt, Shannon. And from your perspective, you are obviously advising companies and seeing some of the day-to-day issues that all over the world companies are trying to deal with around complying with something like GDPR. Do you have some insights on some key insights or clarification that, in your view, result from this guidance? Like, what does it mean to companies to get this kind of clarification?
So it's a great question. I think it almost, and I would love to hear from the other panelists, but it almost raises as many questions as it clarifies in some regards. There's some clarity that we've been waiting for a long time. For me, advising now US companies that directly collect data from individuals in Europe, there was always a question there as to what mechanism they could use for cross-border data transfer. And as sort of the derogations got narrowed by commentary coming out of the EDPB in the past couple of years, it became less clear that you could rely on the derogations. And so there were all kinds of cross-border judo to try to figure out how those US-based companies could sort of justify cross-border data transfers and whether they could unilaterally adhere to the standard contractual clauses, which there was some support for that position by a German regulator. But for me, for some of my clients, it's been tremendously helpful to have that direct collection piece, more clarity there. So I think that's been something that's been really helpful.
Terrific. Peter, Ken, anything you'd like to add on this, on the EDPB's recent guidance?
Just to follow up with Shannon, so when you say there's clarity, is the idea that it's not a transfer if a US site is getting it from Europe? That's what the clarity is now, that it's outside the scope of transfer?
I think so, but I welcome your thoughts on whether that's less clear. But I have a client that has, they sell a bunch of goods into Europe, and there was always a question as to how to implement an appropriate cross-border data transfer mechanism, and sort of thought about, including the unilateral adhesion to the standard contractual clauses at one point in time, which doesn't make a ton of sense, but it was better than nothing. It was sort of justifiable, but now I think it's more clear.
Just one other piece I noticed is corporate families versus the same corporation. There was some language in the discussion that if it's a affiliated company inside a holding company, at some point it really is a different entity, and then you have to go into all these different entity as an importer. To me, it wasn't clear. Maybe someone else thinks it is. If it's the same company with different branches, let's say in France and the United States, it seems as if that might not be a transfer. Reading it, is that? Do people have other views? If it's a different corporation, it's probably a transfer, but inside the same company, by silence, did it seem like it wasn't a transfer?
I didn't think that was clear, personally.
Yeah, I put that into the bucket. Yeah. I put that into the bucket of things that was not clarified necessarily by the guidance. The same company transfer issue, you get into some metaphysical / technical questions about when is a transfer occurring, Peter. I'll give you a really good example that we see technically regularly, and that's when you get into real-time ad tech, real-time consent and preference kind of issues. By the way, I know I don't know if you all are hearing it, but there's a little bit of dinging on one of ours. When you end up collecting the data for, say, a consent, Peter, and you store it just in Europe, and now you want to resolve that consent with the same person who might be accessing a US site, is the data being accessed by the same company to resolve the consent preference on the US side when it's the same person who is doing business with the same company when the data is stored in Europe? Is that a cross-border data flow? Because technically there's an access for US purposes in the same company. I mean, it becomes very, very hard to say, in my view. But my read of the guidance is that it didn't really clarify that one issue clearly, in my view.
Yeah, I mean, I would just make one observation that's slightly broader. Obviously, the guidance has a geographic focus to it with respect to clarifying what is a transfer, and that's helpful. But it does end up in the somewhat paradoxical situation that the companies that are already subject to the GDPR by virtue of a local establishment nonetheless have to employ transfer related safeguards. So that is, I don't know if one would call that a curiosity, but that appears to be one of the outcomes of the preliminary guidance.
No, that's a great point. I mean, it's a great point. Well, look, as I said, there's a lot going on the cross-border data front, not only with Europe, but in other parts of the world. Dan, do you want to jump on a question, or should I give the next one?
Yeah, I have a general question, and it might be that my view is my interpretation of things or reading of things is wrong, but I've always seen a bit of a tension between the CJEU and other European institutions when it comes to cross-border data transfer. And when I read Schrems, it seems that they are on a very different place than others. And if I look at the logic of Schrems and what's said there, I don't see any of the guidance and things coming out to really solve the real fundamental issues that were raised in Schrems, such that I'm not sure how data transfer can really keep going the way it's going. I think that folks put their head in the sand and wait for the CJEU to come back to say no, we really meant what we said. But I really wonder, none of the mechanisms, better contractual clauses don't really solve the big problem, and that is that if the NSA wants the data, they can get the data, and there's nothing that's going to stop that until there's a real fundamental change in U.S. law, or there's some kind of arrangement made. And I don't think a lot of these other solutions are real solutions. So even on the issue we were just talking about, if a company transfer, if it somehow finds its way over to the United States, whether the company is it's the same company, the Schrems issues, all the concerns that the CJEU had in Schrems exist in that situation. So can it just be, oh, cool, we'll just not define it as a cross-border data transfer and somehow we'll escape from all of these concerns that the CJEU had? I kind of think, no, if I'm on the CJEU, I'd say, you're just trying to evade what we've just said. So maybe I'm wrong, and there's all this consistency and somehow it all adds up. But right now, to me, my reading of it, it doesn't add up. And I'm seeing a lot of inconsistency, and I really don't see answers. Are there more answers? Am I wrong? There's something out there? Because I look at this and I say, this is still a mess, and no one's addressing the elephant in the room.
Ken, Peter, do you guys want to jump in on this one?
Yeah, sure. I'll start. I'm sure Peter has thoughts on this too. I mean, Dan, you were I think the very first to point out the consequence of the Schrems decision in turning over this rock about national security surveillance and and the difficulty that that the EU was going to have resolving it once they have. You know, what we're seeing now is regulators, data protection authorities doing what they have to do, which is to try to give content to the judgment that came from the ECJ, and that's understandable and that's necessary. But the larger issue remains, and so what I think is one of the the more interesting developments of the last year or so is the beginning of a discussion at the multilateral level among governments about what the proper limits are on government access to data. That's a discussion that has begun at the Organization for Economic Cooperation and Development, the OECD in Paris, also at the Council of Europe in Strasbourg, another international organization. And in those discussions, Western democratic governments are starting to talk about what their own ground rules are in this area to do a comparative analysis of the kind that the Court of Justice did not do in the Schrems II case.
Maybe I'll just make a couple of points, and then there's about 100 points you could make. One is the effect of Snowden turned out to be even bigger than a lot of people realize. So at the time the Snowden papers came out in early 2013 in June, GDPR was dead. It wasn't going to pass the European Parliament. And it's clear when you look back at the record that when it then passed by 600 something to 15 or whatever, that the sort of concern about the NSA was enormous and really drove the political process and drove it towards a stricter version than it would have been without Snowden. And we saw that in the first Schrems decision, where there was language in 2015 by the court about unrestricted, unconstrained surveillance by the U.S. In my testimony in the Schrems case, I wrote 300 pages explaining the many constraints that exist under U.S. law on the NSA and how there's a very strong case we made that there were the strictest sets of intelligence restrictions of any country, any of the democracies. And under European law, that's not relevant because they're not testing us compared to Germany or France. They're testing us compared to the CJEU standard. So we have a series of strictness about concern based on Snowden in part, that the NSA is and the tech companies of the US who somehow are subject to the NSA are driving a surveillance problem that needs a massive solution from Europe. Given that, however, finding workable ways to do the transfers has not been the priority of the CJEU. And we saw Van Damwitz, the lead judge on these cases in December, saying, well, I thought you could use a bunch of derogations. And he gave a speech being surprised that the derogations he thought would be in place are not consistent with what the EDPB has found to be appropriate derogations. So there's a strictness beyond what I think maybe even the court realized. And when you look at the EDPB guidance on supplemental safeguards and the use cases, most use cases appear to be illegal under the EDPB guidance. And lawyers are struggling to find ways to do things lawfully and find ways to say there's supplemental safeguards. But the language from the court and the language from the EDPB put together put in doubt a huge fraction of data flows in the modern world.
But Peter, I have a question here. Have you seen anyone actually stop data transfers? Because I haven't.
Well, the Ernst & Young IPP report that came out last month found that 20% of the respondents said there had been significant data localization since Schrems.
So there have been changes, but I'm not aware of anyone that's totally stopped.
I don't know. I don't know the answer on that, but to have a survey say that 20% has done major changes in their business to localize in 2 years is non-trivial. And it's the start of what's going to happen unless there's some sets of agreements or understandings. The rules are strict. 4% of global revenue is a lot of money.
Yeah, no, Peter, first of all, Shannon, it's a great point. And I think the points are well taken. When I see that statistic, I end up with a little bit of a Bill Clinton-ish, I wonder what they mean by localized, really. Well, a lot of the companies that I've seen, when you see it, both companies and otherwise, when they say we're, quote, localizing, I've often heard that mean we're storing it locally and accessing it or processing it in a lot of places, So I'm always curious what they mean when they say localized, because to do business in a practical way, as Shannon was saying, and not affect the other interests of your customers in a very adverse way requires accessing the data on a cross-border basis, even if it's being, quote, locally stored in Europe. I don't mean to be too pedantic about this, but a really good example of this, if you're just trying to think of your customer, assume for the moment a hypothetical where you have a business that wants to do right by their customers and wants to obey the law, okay? Hypothetically speaking. And they say, you know what? My customer, when they were in Europe, they actually gave me a consent on one thing and no consent on the other, hypothetically. Now, that company, if they just store that consent in Europe, when that same person comes to the US, they're making you re-say the same consent again, which is a terrible experience for the consumer, right? So we see companies saying, we want to make it easy on customers. We want to make sure we're persisting their choices and we don't make them do it over and over again. And that's that a lot of the ad tech world is trying to worry about that consumer experience. Now, if you don't let the US entity access that, quote, localized data in Europe, you've got a bad customer experience and you're making them give you the consent again. So I'm really curious how this is actually implemented, Peter, on localization, and whether they're actually purely hermetically sealing the data in Europe and not doing a data transfer. I'd be interested in that.
Well, I've written about this in various places. We have a new study coming out, I hope within a month, on the effects of localization on cybersecurity. And one of the standards you use there is ISO 27001 and 002. There's 14 controls. And according to our research, 13 of the 14 cybersecurity controls get disrupted by actually implementing localization. It's very hard to do centralized management of a company's computer system. And the one other finding that we emphasize is it looks like it's unclear whether you can buy cybersecurity services from overseas, the way Cloudflare got kicked out of Portugal. And that's a $200 billion industry annually for cloud services related to cybersecurity. And if Europe, for instance, can't buy US-based cloud services and they're using second best services, that puts a target on every European organization because they're not using the best cybersecurity that other people are using. They're using lesser cybersecurity. There's been no answer from ENISA, the cybersecurity regulator in Europe, or from the others, but these could have really major consequences for doing cybersecurity in the name of data protection.
Let me just throw in one other nuance in the localization discussion that has recently become evident. You know, Justin, you're right that the focus has primarily been on local storage. But what we're starting to see now are criteria emerging in countries like France in the context of cyber security standards, that there be limits on foreign ownership of cloud companies that operate there, and also somehow immunity from foreign jurisdiction, and that latter point is directed very much at demands under, for example, U.S. law, Section 702. Once you add those criteria into the conversation, it becomes even more complex, I think, for U.S. companies to deal with.
Yeah, again, Ken, I completely agree. You know, one thing, and then I'll hand it over to Dan for you to pick up the next question. But you know, as you know, WireWheel and Dan's participated, and I know a number of you have. We host something called the Spokes Conference, and it's a free, open discussion. Our next Spokes sessions are December 7th and 8th. And the number of different sessions that we have that are around the engineering, consumer experience, and technical, like Peter's covering, challenges of cross-border data flow, it's a lot, because the consumer experience side of it, you know, I fundamentally think, Ken and Peter and Shannon, that a lot of the global privacy laws from a human perspective, from a human rights perspective, are trying to look at it from the perspective of a human being doing business with a company. That's supposed to be the underlying driving principle. And the more you compartmentalize the data, there are actually technical consequences, like Peter pointed out, of making perhaps the data more cyber at risk. And you also make it very difficult sometimes for the human being to understand the choices and persist them in a simple way. Compartmentalization and sort of localization actually can have a countervailing difficult set of challenges to the consumer. And if you want to see what I mean, if you all get a minute at some point, VPN into Europe and try to use a search engine. If you've ever done that, you will stop in your tracks. You literally VPN over, and the first thing that pops up is a screen with something like 8 to 9 mandatory choices, most of which I'm a lawyer and I've worked in the field. I can't even understand what they mean, each of them, and you have to make a choice in order to be able to do a search. Like, is that really kind of better for the consumer? It's hard to know. Anyway, Dan, I'll go over to you for the next question to our panel.
Sure. And I guess as a segue from this to my next question, I do think that, really until this larger issue is addressed, which is government access to data, the issues that Snowden exposed, with what the NSA was doing. And I always thought that, it's very short-sighted to kind of get the kind of short-term win that the government gets by, engaging in the surveillance or breaking the law to do it, which I think was done in these instances. And then the long-term consequences have these ripple effects that I think ultimately are really bad in the long run. And we're now seeing that right now, the fallout of that. And until that issue is addressed, I really don't see how we're going to get the kind of resolution to this problem, because that's the elephant in the room that just has to be addressed. And until that happens, I think every attempt to kind of do it is just kind of putting Band-Aids and partial solutions. But I think if we can figure out a way to address a reasonable, thoughtful approach to government access to data that is, where there's a robust following of the law, then I think this problem starts to get a little better on the good faith side of things. On the bad faith side, countries that are using this as a way to achieve other goals other than protect the data. That's a pretext to greater control or everything else. I mean, that's another issue. And I think we're seeing that with the localization. It's not all driven by pure motives. And I'm curious what your thoughts are on some of the new privacy laws out there that are pushing more for localization, and then where you see this trend going, because ultimately I think that we're seeing this movement toward more localization progress. I don't think it's a good thing, but what happens? What turns the tide? Or is this kind of what we're going to have to, this is the way the world's heading and it's just going to be a slide into this direction? Or is there going to be something that turns the tide on this? And what would that be?
Well, I mean, let me just start off as someone with a background in international law. This is obviously something that cries out for a global solution, for a global convention of some sort. But simply asserting that proposition also shows how difficult and unlikely a prospect that would be when you're trying to put in the same room for a universal convention, authoritarian as well as democratic governments. I think it's going to have to build from smaller groupings, perhaps like the ones that are beginning to talk about the subject already at the OECD and the Council of Europe. there's really a lack of an existing international forum that's dedicated to privacy issues. I mean, even the OECD and the COE have their disadvantages. The OECD has no experience in national security. The Council of Europe, likewise, they do have experience in the privacy area. So we're talking about bringing together groups of experts that fundamentally don't know each other. Privacy experts from countries and national security surveillance law experts. Justin, you and I had this experience in the negotiation with the European Union, where it was necessary to bring those two communities into contact with each other, and eventually there was some understanding that grew between the U.S. and the EU side. It wasn't easy, and it didn't persuade the ECJ at the end of the day, but it's a start.
Can I make a couple observations? One is I wrote a piece that was just published on our cross-border data forum site within the last 2 weeks about how to think about what's necessary in democratic society for public order, law enforcement, the economy, national security. And one odd trait of the CJEU and the EDPB in Europe is neither of them have any competence over national security or expertise in-house over national security. And yet they're issuing guidance and decisions with very large implications for national security. There's other institutions, for instance, the European Court of Human Rights in Strasbourg has a long history under its documents of looking at national security and trying to figure out how to do what's necessary in a democratic society while protecting fundamental rights. Theodore Christakis, who's another fellow for the Cross-Border Data Forum, has written about this divergence between Strasbourg, the Court of Human Rights, and Luxembourg, the Court of Justice of the European Union. And the Court of Justice, the Human Rights Court, with this experience, has a much more nuanced way of thinking about and talking about and testing for national security concerns, including a margin of appreciation for governments to address emergencies and problems. And it's, I think, a problem to have a partial solution where you don't have people knowledgeable about the national security side proclaiming things based on their lack of knowledge of national security law. It's bad institutional design. And because of the limits on jurisdiction of the Court of Justice of the European Union, they've specifically been excluded from becoming knowledgeable about national security. And you're the ones giving opinions about FISA and things like that. So there's an institutional design problem, and Europe hasn't wanted to sort of acknowledge that and have a path where national security gets discussed in a room with people who've worked on national security.
Yeah, I mean, if I may on that one point, maybe a little bit of reaction I would have on those points would be, when I've read the High Court, European High Court's decisions, Peter and Ken and Shannon, I see it largely focusing on kind of a very important but technical concept of redress, which is a reasonable core competency of a high court, right? A high court in Europe, I think, reasonably can say with confidence, this is what is required in terms of kind of independence and redress without bleeding into things that are outside of their core competency. And I think that's a fair point for a European high court to weigh in on. And that's where I think some of the, I have read commentary outside this group that overgeneralizes what the actual holding was in the Schrems case. And I think, I don't know that it fully gives credit to the way that the court has been addressing the issues, because I do think it's fair, to be honest, even though I was on the other side of the table in representing the United States, I do think it's fair for a country or a group of countries to say, if you're taking something that is a European sort of controlled asset, you have to abide by this rule, and this rule means you have to have this level of judicial review over it. That doesn't strike me as that troubling, to be honest, as a international legal issue, Peter, if I may say.
Well,
I do think.
Yeah.
Sorry, go ahead.
Well, Ken and I have co-authored on redress and are continuing to work on that. My own view, I could have views on what the scope of redress should be if I were a European lawyer. But I think for the United States looking at privacy shield negotiations, it's important to build a redress mechanism that meets the rather clear criteria of the Court of Justice, that has an independent tribunal, that has the ability to issue binding orders, that has a way to accept complaints, from Europeans on behalf of the data subjects. And I'm hopeful that such a strict regime can be built within the United States that would respond to the court's requirements on that. So rather than argue against redress, I would just say, I think, and I hope the negotiators will get a really strong and effective redress mechanism.
I to be honest, I'm with you. Look, Peter, you've been at the cutting edge of this for a while, as if you can, and I think it's achievable. I mean, especially on an essential equivalence standard. I don't see the European High Court saying you need to literally mimic European frameworks. They're saying do something that's fundamentally indicative of an independent review, and I don't know. That doesn't strike me as irrational, and I think someday, I hope we have a U.S.-based, law, and I think a U.S.-based law is going to require the same thing. If we end up allowing data being moved out of the U.S., I think we're going to expect a certain level of protection when it goes to another third-party country. So I think on those sides, I think we're all probably in agreement. I think the concept that the redress requirements is maybe fundamentally attacking or singling out the U.S. on our collection process, it's hard for me to say. There's so much, if you just read the paper publicly, there's so much international data collection occurring, it appears, from countries all over the world outside of the U.S. for national security purposes. It's hard for me to believe that the European High Court or anybody thinks that the U.S. is somehow doing this and we're the only ones doing it. And when we talked about China at the beginning, there's data privacy laws in place with a number of countries that have been publicly covered as doing surveillance extensively. So I don't really see it as a U.S. focused issue in my view.
Yeah, I would think as I read the decision, I mean, yes, it is about the U.S., but the principles in it would apply to many countries around the world, including countries that have been deemed adequate by the EU. And I think that, they're really, I ultimately agree with a lot of the court's criticisms of U.S. surveillance law. I think our surveillance law has a lot of weak, problematic spots to it. And that should be addressed. And I do think that there really needs to be a greater international solution, as Kenneth has said, to this issue. It's not going away. And I think the only way, but things just kind of go on because they have to go on. But it's not going away. It applies to a lot of other countries, and folks just aren't really focused on that until someone says, stop that, stop this, stop whatever. It seems to go on. And it seems that from what Shannon's saying, I think a lot of, companies, still kind of have to go on, and they kind of go on. And it's like, I guess, adding more police to patrol the highway and people speed, but they'll slow down a little bit whenever they see a police car, and then they'll speed up a little again when the police car is out of sight. I'm not saying you're saying this, but I'm just, but basically that seems to be what I see going on. So, and I wondered strategically, what should companies do? Because a lot of this is part of this is really outside of what a particular company can do. I mean, a company can, I guess, try to do some kind of analysis of a foreign country's law, which I always think is absurd to kind of say, oh, well, every company is supposed to somehow become an expert on, the world surveillance laws to transfer data, which that part is totally impractical. But what does a company do, and how do you figure out what the right level of compliance is when I don't think there's actually a way to fully comply the way things stand now?
Shannon, this is probably a perfect question for you. And honestly, even if you would mind, without citing any particular examples, the sort of concept of transfer impact assessments right now under the guidance makes me laugh every time I read it, fundamentally, but you're the one that's actually counseling clients around this. So do you mind giving us your perspective on how companies are dealing with both of those things?
Yeah, sure. So I think that, we've all recognized that there are a lot of legal fictions that go on in the world of cross-border data transfer, from, Dan, to your point, that other countries don't have federal or surveillance laws that are highly similar to those in the US, including, without limitation, those which have received adequacy decisions. So then it comes down to, from a very pragmatic perspective, what do you do in these scenarios? And, we don't want to treat it as a box ticking exercise, but at the end of the day, you have to put together a defensible narrative as to how you are justifying your cross-border data transfer, and lean a little bit on the risk-based approach to the GDPR and cross-border data transfer, and make sure that you have a defensible story to tell about, you've done your transfer impact assessment and you've reviewed it and decided to make appropriate adjustments, including potentially localizing data in Europe, even though, perhaps it can still be accessed in the US. But I feel like, provided you can show that you took these steps and you made these efforts to implement appropriate safeguards, and you did your transfer impact assessment, you're going to be in a reasonably good position vis-a-vis a regulator coming and taking a look under the hood. And they're bound to take under consideration the steps that you took to comply with the law in issuing any kind of fines. So it's sort of looking at the sliding scale of risk and figuring out what your risk tolerance is. And I think that's the position that a number of companies are in right now, who are being told that the new standard contractual clauses, which have not yet been drafted or issued, and there's no clear timeline for when they might be drafted or issued. In a conversation, I think, with the IAPP earlier this week, the EDPB Secretariat indicated that it was not recommended that those companies would go ahead and enter into the new standard contractual clauses, and that they should wait for the new standard contractual clauses, which is just sort of tricky for those companies to swallow and harder to, advise them. But again, we're used to this complexity, and we talk a lot about the sliding scale of risk.
I think it's worth pointing out also that it's not just, or even primarily, U.S. companies that are facing this situation. I moderated an event for the Atlantic Council last week where we had the general counsel and data protection officer from a French legal research services company, sort of an SME, talking about the fact that the burden for this really felt most heavily on European companies and on SMEs, and that they were dealing with a sort of an unprecedented sense of uncertainty about ultimate liability that they might be assuming. So this is not a comfortable situation for companies on the other side of the ocean, even though the jurisprudence was originally developed with the United States in mind.
Yeah, and if I may, there are two great questions that have come in from folks watching today that I just want to pose to the panel. And Shannon, Ken, Peter, this has been, as I expected, just a terrific discussion. I know we're getting towards the end of it here in a few minutes, but I'm gonna sort of read out a couple of questions if folks don't mind jumping in. One of them is both a question and sort of makes a very important point. We're talking about transfer impact assessments and the burden on companies. But one of our attendees asks, does the panel believe that transfer impact assessments that we're all doing will actually have a positive impact on protecting an individual's personal data? So in other words, look at it from the person's point of view. Do you see, any of you, improvement on the protections to human beings around the world by virtue of transfer impact assessments? What do you think?
Well, the theory would be, for people who support doing it, is that the company might decide to shift from jurisdiction with high risk to jurisdiction with lower risk of violation of human rights. So if that were to happen, if you do your impact assessment and say, oh, country A looks risky, country B looks like it has better protections, then you could have a reduction in risk to the individual. I'm not sure.
A phenomenal lawyerly answer, Peter. I love it. That's a great answer. I mean,
well, at least, okay, it's good when a professor's called great lawyerly answer instead of a great professor academic answer. But that's the way the individual could get protected. That's the theory behind it. But when companies are doing it to come up with an effective strategy to counter the risk, and they're papering themselves by having the best story they can, it's hard to see how that's going to very much affect and help the individual's protections.
It'd be good if there's some data on this. It'd be interesting to see, are we actually seeing any movement? My cynical guess is no. My cynical guess, everything's the same. We just have more paper. But maybe there actually are material changes, in which case then we could measure a real palpable effect here.
I think the IABP Ernst & Young study that just came out has survey results from hundreds of privacy professionals saying what they're really doing, and there might be better data in there than you'd expect.
Go ahead, Ken.
Well, I was going to say one comment that I have heard from corporate data protection officers is that there is now a greater focus within companies on what data they have and where it's going. And this of course is what you do for a living, Justin, with this sort of mapping of data. But there is, I think, a greater consciousness that has come as a result of the new requirements. Whether that actually has changed practice very much, I think all we have so far is really impressionistic sorts of answers.
Yeah, and I think look, in my practical view, the actual redress items in the Schrems decision that spur now transfer impact assessment under SCCs and others, if we were all just going back to law school and assuming there was no political challenge here, Peter, you would say that it's very difficult to imagine that you solve Schrems, which is really calling for independent review with standing for individuals who are worried about national intelligence collection. That's fundamentally what I read Schrems as asking for, setting aside anything else. It's really hard for me to imagine that the High Court imagined that it would be solved by doing transfer impact assessments in which a company is trying to guess about the data collection practices by national security agencies in third-party countries. Like, on what basis is anybody making that judgment? So I think it's a fair question to ask. I think there is something about companies actually engaging in the review. I think fundamentally, there are companies that are trying to do really good faith reviews about where the data is going. I think, Ken, to your point, going through that exercise and at least knowing at a company that data is going to another country and then making a fundamental review and making a decision that it's okay that it went there, that's a big improvement on what it would be if you just never had to even know that a transfer was occurring, right? So Peter, to your point, I do think there is some fundamental benefit out there. I think the part of the transfer impact assessment where companies are assessing the kind of national security infrastructure or third-party countries is somewhat amusing. I don't know. I don't have a better way to put it. I don't know what you get out of that. I don't know, Shannon, Dan, any other comments on this one? Because I think we're hitting the top of the hour. I did want to make sure everybody got a chance to say their final word on cross-border data flows before we end today's session. Shannon?
Well, Justin, I think you're right that it is making companies be a little more thoughtful and intentional about their data transfers by having to implement or fill out transfer impact assessments. On the other hand, I'm also seeing companies that are challenged by the administrative burden of transfer impact assessments. And pre-filling them out to send to counterparties on the basis that the vendor is not going to have a deep understanding of how to complete it, and asking the vendor to sort of ratify the pre-completed TIA in order to check a box. And from that perspective, what are the protections provided to the individual? I don't think they're that significant. But in this space in general, it's gonna change in a couple of months when the new SCCs come out, when the UK comes out with their final international data transfer addendum. But for the moment, there's a lot of paper.
Yeah, I agree. And obviously, in my view, there will be a new privacy shield and a new adequacy finding as well. I'm going to stake out the territory and say that it will happen. And I do think that will help a lot in terms of the need for these, in my view. But Dan, Peter, Ken, final closing words from anybody on this subject?
Just very briefly, Ken, along with the Atlantic Council and teaching at Georgetown, is a senior fellow with us at the Cross-Border Data Forum. I'm the research director at the Cross-Border Data Forum. We're writing about these issues all the time. Cross-border issues is what we do. And so our blog and sign up for our emails might turn out to be interesting for folks if you're trying to follow this topic.
Oh, thanks, Peter. You should post that in the chat as well, if you don't mind, the way that folks can sign up so that folks can do that. Ken?
Yeah, I mean, just to offer sort of a coda to your prediction that we will achieve a new, hopefully better named agreement with the European Union. I hope that doesn't then divert the attention of governments entirely from the larger question that Dan has put on the table of how you reconcile government access to data with commercial data flows. I think that question is going to continue to be with us. It's going to need the engagement of governments across the world. We're starting to see encouraging signs of that, but it's going to take continued initiative.
That's a great point, Ken. Dan?
I'd love to see a kind of more public analysis of the countries and how they're doing that would be relied upon. So rather than having every company do this kind of internal paperwork and research, it seems to be reinventing the wheel. And I think a more effective mechanism, if the goal is to drive countries to do better about protecting against government access without sufficient protections of law and redress, then it'd be nice to have a more public thing to draw upon. Work that's done that sets forth a report that looks at what every country is doing, that then companies could just rely upon that report, and that could ultimately drive maybe a competition for countries to look into this and address this, which might be more effective than the kind of quiet, everyone does their little impact assessment independently and no one really sees it. So that might be an improvement. And I definitely think, there's a lot of work that the US law needs to do. And I think very unfortunate Supreme Court cases that have made things a lot worse than they really should be. And I think other problems around the world that need to be addressed, as Kenneth indicated. So I hope that this is an occasion to start doing that. Will we see another privacy shield? I hope they don't change the name, because I had illustrations made for Safe Harbor when that was there, and then they changed it to Shield. So I had to get a whole new set of illustrations for Shield, and now they better not change it to Privacy Safe or something else, because then I need to have another set. So maybe Privacy Shield 2.0, even though it's, I guess, now 3.0, or they can say take 3. I do wonder if I kind of thought Safe Harbor was never quite addressed the real concerns that the EU had with the problems with the incompatibility with the directive and transfers there. I thought that Safe Harbor was kind of a little bit of a cheat. I think, sorry, Justin, but Privacy Shield, I think, was kind of it addressed a little bit, but I'm not sure it fully, really solved the problem either. So I wonder, is the third one going to satisfy the CJU. So it might be the kind of thing where you keep doing it, and then wait a few years before Schrems runs to the CJU to strike it down, and then we'll just have various iterations of inching step by step to various shields till we get shield 10.0, which might finally get there. But maybe that's sort of my prediction. But I think you're right. We'll probably see another shield. Will we see a shield that the CJEU blesses? I'm not so sure.
That's why there needs to be a good. That's why there needs to be a really good redress mechanism that addresses the criteria of the court. That's where their doctrine's most clear of what they're asking for, and the U.S. should try to build something that fits that.
Yeah, first of all, I don't mind the criticism, Dan. I think it's probably once every 3 months that I get leveled in on over Privacy Shield. So I'm glad we hit that towards the end of the year now. That's a nice one to check off the box. So I think I have about a quarter until you lay into it again. I don't think it's a bad thing at all to have incremental progress on a big area like privacy. I mean, to be honest, Privacy Shield brought 4,000 or 5,000 companies in its first round to voluntarily declare and try to abide by much stricter privacy standards, and that's progress. That's material progress, and I like the directions it's going. I think I won't tell you where the name came from, but I have no pride of authorship, let's just say, over the name. But I do think it'll happen, and I do think it'll happen hopefully soon. And we spoke to Bruno Gencarelli at the last Spokes, and he made clear, and I've heard this from multiple sources, that the entire focus on the next Privacy Shield is around redress. It's not changing the commercial terms. So if you've complied with, Shannon, all of your companies who complied with Privacy Shield, as long as they kept it up, when you have a new Privacy Shield, there's not new obligations, in terms of commercial obligations for companies, which is important at this moment. And, just one final thing, as I mentioned, Spokes is coming up less than a week from now, and it's free and open for folks. We have sessions on third-party assessments, which are covering transfer impact assessments, Shannon. And it's all from the practical day-to-day. That's, on the 7th, and there are 2 separate sessions where leaders from companies are coming in to talk about the practical effects of running these kind of assessments. So I think folks who are worried about those would certainly be great sessions. And the whole issue of digital advertising and global patchwork of privacy laws is being covered on both December 7th in a phenomenal session with some former leaders from the FTC speaking, and then a session on the 8th, which is all led by some of the most senior former privacy engineering leaders from Facebook, Uber, and others, trying to talk about literally how do you engineer from the back-end systems some of the compliance steps that, Peter, you've covered. And believe me, the security issues that are involved are a key set of discussion. So, let me end by saying, first of all, I hope everybody joins us at those. But as always, on behalf of Dan and myself, I really appreciate Peter, Ken, Shannon, each of you coming to join us and share your thoughts with the community here today. And the recording will be up on Dan's site. It'll be up on the WireWheel site. And I look forward to seeing each of you soon.
Thanks very much.
Thank you so much.
Thank you.
Bye-bye.
Thanks, everybody.